Hello, how is everyone? Thank you guys for waiting. Oh my goodness, it took a very long time to put this show together today. I really appreciate you waiting. So nice that we could actually go at a reasonable hour. How is everybody? Hey, Honeybee and Death Queep, and of course, Justin, thank you for priming the room as always. Yeah. Yeah, I'm here. Thanks, guys. Hey, Kathy. Bon Dewey. Dewey. Bon Dewey. Okay. So let me put this. Hey, Nash. How are you? Bonnie. Hi. Y'all are so great. Bon Dewey. It's reminding me of I don't know why. A toupee. I don't know what. Why does my brain work like that sometimes? Okay, let me slide this over. Good now that I'm live. Yeah. Oh, yeah. No, thanks. Oh, yeah. No, I definitely. Bon Dewey. Etouffee, Bon Dewey. Okay, Nash, let me fix some of this stuff. I keep on telling Nash I'm going to fix it. Don't look, Nash. Don't look. I need my stage mom over here. Yeah. Me too. You know what? This is actually. Ah! Tu parles en français? Yeah, I did a little shopping on Poshmark. So it's all good. Nice sweaters always look really good. I get really tired of the overpriced sweaters that are like not made out of good material. Yes, I am. Yes. You guys, I have Lacoste out the wazoo. I haven't tried Vinted yet. I really want to, though. Okay, I'll definitely check it out. How's everybody's day? Yeah. It's funny because sometimes, like, the less you try, the better the look ends up looking. I just have been throwing on these sweaters because I'm behind on laundry, to be honest. Always. Yeah. So let's see. I think we have a couple of new people. Bondue. Etupe bondue. I think you are new, my friend. Definitely subscribe and turn on your notifications. Let's wait just a couple minutes to let people get in here. I don't know who else is going tonight, but yeah, I love Vivian Hex. Lacoste is actually you can actually get it for a decent price right now, and it's still like 100% cotton. It's all the vintage stuff is really good. Oh, you lurked before? Well, now you're an official member to our semi-pro setup. We're gonna get there, Nash. Tammy, hi, welcome in. Oh, wonderful, Bon Dewey. Am I saying it right? Am I saying it correctly? What should I call you? Well, if you like the way I break down the law, you're gonna like it tonight. But everybody really needs to grab like some caffeine or nicotine. Yes, badly. I know we do need the metadata. Bon, I'll call you Bon. Bon. Okay. Yeah, and thank you to all my mods. Seriously, y'all are awesome. Oh yeah, of course. Anybody's welcome in here. Okay, good. You're gonna need it. And you know what? I'm preaching to the choir because I think most of y'all have been in here, or you were in here for the aggravated murder presentation. So let me restart, okay? Let me walk us back so we can figure out kind of where we're at. as you know, the aggravated murder presentation, right? That was based upon, I took it from the prosecution's memo, right? Saying like, okay, once a preliminary hearing wrapped up, both sides, submit a brief. But really, it was the prosecution that goes first. They did, and then the defense presented their defense brief, which was super thick. It's sitting right here. It's freaking, is this it? 41 pages? No, it's more than that. I don't know what the deal is. I think I'm missing half of it because I had to use the rest of it for my printer. Yeah, I had to recycle. I'm pretty proud of myself. Anyhow, so when that happens, usually there's a third brief that's filed, and it's the reply. So I was describing it as ping pong. So you have the initial brief, which was the prosecution memo in support. So if you ever see ISO, that's in support of, binding over for trial. So basically saying to the court, like, okay, here's a summation of everything we argued, and then the defense does, and sometimes we use different words, but really it's an opposition. I don't think they called it an opposition, but it's fine. And then it ping pongs back to the state to give one last reply. And that's as far as it goes. So I had been waiting on the reply to come out, and then it did last week. And that's what this presentation is going to be on. That's why I was kind of saying you might need a little bit of a primer for what we discussed in the aggravated murder. But then whenever I was putting this show together, oh my goodness, you guys, I realized you really don't need one, but we're going to go over some of the same things that we went over before, but there's a little bit more of a context now. The context has shifted, right? Because what we're doing is I'm telling you, well, I'm presenting to you the holes, the pitfalls of what this reply is. So we'll call it brief number 3, right? And these 3 briefs, so prosecution, defense, prosecution, these go in front of the judge who is about to render what I think is, and I'm not sure on this, we call them like a tentative ruling. And essentially that is the court comes out with a ruling that says, and it's not etched in stone, right? He says, hey, this is what I'm planning on ruling, and this is why. And that gives both sides the opportunity to argue or do the oral argument, or like if you are, I don't want to say on the losing side, but if you are on the side that, he's not ruling in favor of, you can submit to the tentative, which means, you know what, judge, like, all right, that's fine. We'll just submit on the tentative. It happens a lot in civil court for, other matters. And then you don't have to do an oral argument. So I think that's the way it's going to go. I know we have a hearing coming up on the 1st. So I'm anticipating we're getting a tentative ruling, or at least that day he's going to tell people or tell the parties how he's going to rule. And then in a couple weeks, they're going to have the oral arguments. But don't hold me to that because I'm not sure exactly. Somebody was telling me that the September 1st hearing is supposed to go for a while, but it could be that they're going to wrap up some other matters while they're in court. Okay, let me see what everybody's doing. Fast Eddie, is this your first time in here? Welcome, everybody. Hey, everyone. Yeah, y'all are joining in good time. I was just kind of laying down some of the foundation. This one is like so cerebral, you guys. So I'm going to make it as painless as possible. And it was, like you guys know, it's like a smattering of arguments, and then I'm splicing them together. But for today, what I've done is I've literally taken the prosecution's reply, okay, like the whole thing. And we're just going to go through the aggravated murder part today because that's the primarily what, we all really care about. The other ones, like, we could get to them eventually if we wanted to. But it's the first 11 pages of of their reply. Good to see you too, Barefoot. Boots. Good. Bradley's a brainiac. All right. This requires so much brain energy, you guys. I love what I do, but holy moly, it is like there's very little stuff to do in passing where your brain can just kind of like take the back seat, especially when you're analyzing all day. And I'm not even kidding. Even though I was like, don't recreate everything that I've already done because a lot of it fits into here. Still trying to go through it to figure out a way to present it to you guys. Oh my gosh, that took me all day. So worked early on my stuff, and then I've been working all afternoon on this. Okay, yeah, actually, let me turn the comments on. Love that you guys are in here. Thank you so much. Just like and subscribe if you haven't, but I think you're all subscribers. And yeah, we'll go ahead and get started because it's like, it's a lot. But as you know, I'm going to make it as painless as possible. Okay, so if you've been in a couple of these, some of this is going to look familiar, okay? But I want to give everybody who's maybe seeing this for the first time or playing it on replay, your foundation. All right. So I have a couple of things here. We're going to go back over probable cause. And I think Justin and Kathy can probably recite this now by memory. Okay. So I think that this is so important and foundational to understand, especially, well, in light of like all of the misinformation that I don't want to say the other side because I'm really trying to look at this objectively, but I'd be remiss if I didn't say like the way Blake Knapp and some people at TPUSA have been talking about like, oh, well, why didn't, the defense do this or say this or that? It's because they don't understand the concept of a preliminary hearing, or they are purposely trying to make the public who, doesn't have time to sit here on something like this, or wouldn't know the first place of learning it, or, most people aren't attorneys, and most of us attorneys are not criminal attorneys. I'm not. So it took me a while, not as long as, most people, but I had a basic understanding and I had to make sure I was right. But yeah, at this point, for sure. So I want to just go back over quickly what the purpose of a preliminary hearing is and what the limitations are, so that you understand why the defense initially did not present everything that we expected them to, or didn't mount to defense. This is not actually a hearing for the defense, really, right? The onus is on the prosecution to meet what we call a prima facie case, which is you have all the elements of, your charge, like aggravated murder. And the case has to show, the prosecution has to show the court, hey, we've met our very low bar burden of, establishing probable cause. And that does not mean that it's legitimate. You have to take it at face value. Literally, the limitations of the judge are to believe everything that the prosecution is presenting, because he's not weighing the evidence. He's just saying, okay, we have to, do you even need to be in court, right? So to the defendant, like, do we need to put this defendant through trial and all the money and time? And what about his liberty? So yeah, the most important thing to remember is that the prosecution has to open the door during the preliminary hearing, meaning they have to bring something up for the defense to even address it. It's not like the defense gets their turn to bring up something that the prosecution has not. And the defense is pretty much limited to cross-examining the witnesses that the prosecution chooses to bring up. So it's not like they can just call their own witnesses right? That's her trial. So when you really see the defense has their hands tied, it helps you to understand more and have a little bit more faith in what's going on here with this case. Okay, so let's quickly go through this. All right, the purpose of a preliminary hearing is obviously not to determine the guilt or innocence of an accused, right? That's for the jury. If the evidence supports probable cause to believe the crime charged, and tonight we're going to look at aggravated murder, but for the record here, they have to meet probable cause for all 7 of their charges. And, we're not going to go down that road tonight because the aggravated murder one is big enough. Okay. That the crime charged has been committed by the defendant, and it's basically to say that the magistrate, who's the judge, is whether he's gonna bind it over for trial. That just means, is he gonna send it to trial for the jury to decide? So it does not require proof beyond a reasonable doubt, as is required for the conviction, right? So our standard here is probable cause. It's real low. It usually, the burden is met when they present a police report, whether or not the police report is later on in trial found to be erroneous or, whatever. So that's how much deference they have to give to the prosecution. Okay. All right. And then the role of the judge, right? So the judge also has his hands tied in a sense. He's really there to kind of to referee and to accept evidence into evidence. He's not there to say one piece of evidence is better than the other. In fact, it doesn't even matter if the defense presents evidence that it opposes the prosecution, right? Like, it doesn't matter. Even if the defense has the best evidence and the prosecution has crap evidence, at this stage, it comes in. And it's not until later at trial. And I hope that kind of helps dispel some of the cloudiness around it. Okay, so magistrate at a preliminary hearing must view all evidence in the light most favorable to the prosecution and draw all reasonable, and I want you to bookmark that in your head, reasonable, because that's what we're going to talk about tonight, inferences in favor of the prosecution. So he really only has a very limited role of judging the credibility. And he can only disregard or discount the prosecution's evidence if it is contradictory, inconsistent, or unbelievable. So, for instance, a good example of this would be if the prosecution presented surveillance footage and it had a black man, right? And we know that the defendant is white. Like that's just unbelievable, right? So that's the extremes of what we're talking about here. And at the bottom, like, the judge can't prefer one piece of credible evidence, like from the defense, over a conflicting piece of credible evidence from the prosecution. Okay. So let's go ahead, and I know some of y'all have seen this too, but we're just going to kind of breeze through some of it. We're going to be going back to this tonight a couple of times, just depending on where it's at. Okay, so aggravated murder and why it matters in this case. Why it matters that they didn't just charge him with murder. Okay. So in the state of Utah, if you charge someone with murder and you convict them, then it's 15 years to life. That's the sentence that can come down. However, if you charge them with aggravated murder, you're up for the death penalty. And we've talked about this before. This really doesn't sit right with me because Charlie, let me just actually go through the elements here. So defendant intentionally or knowingly caused the death of another person, right? So Charlie, that's in both of them. Essentially, for this case, we'll say murder, caused the death, because what they're saying, remember, we have to take what they're saying at face value. Like, they're saying that it is Tyler, so at face value, we have to say it's Tyler that shot him, even though most of us don't believe most of that, but it doesn't matter because that's what's being presented in front of the court. Okay, so if you knowingly take someone's life, in Utah, you can be charged with murder, sit there 15 years to life. However, if you did that under circumstances in which the defendant knowingly created a great risk of death to another person other than Charlie and the defendant, you can be found, you can be convicted of aggravated murder. What's crazy here is that in both scenarios, Charlie died, right? Like, you're still going to get justice as far as, the state can advocate for his justice, right? But on the aggravated murder, nobody else even has to get hurt. And in some of the cases I can understand, and we'll go through that tonight. But when the state is bringing a case on behalf of the state, it's the people of the state, because the people of the state don't want this happening in their state. And it's also on behalf of the victim. Charlie is the victim. But if nobody else is named as a plaintiff, or, in this case, it would be like, yeah, it's the state bringing it on behalf of anybody. So even if it was like somebody claimed assault because, of the circumstances around this, that would be something, right? But here we don't even have anybody claiming assault. So the only victim really is Charlie. So how does reaching for the death penalty because of other people do any real justice for Charlie? Because if they miss out on this, I don't know, it just seems very greedy to me. Okay, so go back on that. All right. Yeah. Right. Everybody thought Erica was the victim. She's the representative. She's the victim representative. Okay, so let's go ahead and get started on the brief that they submitted, because I know that you guys know that now. All right. So I've broken this down into a couple different documents, and I just want to read, let me see, I'm going to read it from over here so I can read it a little bit better. Okay, so the page numbers over there, that is for your reference and mine too. Those reference the page number on which it can be found in the reply brief. Okay. Also, I have, like, one thing about grammar. I'm crazy about grammar when it comes to writing for the court. Whenever it comes to texting or speaking, it's different. It's a different set of standards. But just professionally, there are some things that should not be in here, like the word that. The word that drives me nuts. So anytime I'm reviewing something, to keep my place and to make sure that I'm paying attention, I will strike out the word that. So, I mean, if y'all zoom in on it, you'll see it. All right, so introduction. This is how they start off. They say, defendant does not challenge the substance of the evidence demonstrating he was the person who did all this, right? And then I say a challenge to the substance of the evidence presented by the prosecution is not even appropriate at a preliminary hearing. the court must consider the prosecution's evidence at face value, even if not true. So I'm really shocked that they started with that by attacking the defense for not challenging that it wasn't him, because that's not even the scope of what we're doing at a preliminary hearing. So already they started off on the wrong foot with me. I mean, I'm really shocked that they said that. Okay, so rather, he merely asserts the repeatedly rejected claim the overwhelming evidence establishing some of these facts could not be introduced as reliable hearsay. And I have that bolded because that is important. And he raises this is what they say, no valid challenges to the evidence supporting count one and then all the other counts, right? So here I've said the valid challenge is the case law and the arguments presented by the defense, like all 40-something freaking pages. And moreover, an argument regarding the reliability of hearsay is totally legitimate. And just let you guys know, we're only going to look at count one for today. So, they're basically saying they've raised no valid challenges, which is crap. I mean, whatever. Listen, I write briefs too, but you can just tell when they haven't done it here yet, but you can just tell when they get a little bit too big for their britches. It should just be factual. So I'm really trying to go with, I really try to stay objective, but clearly as we go on, you'll see I did not. Okay, so at the bottom here, it says, defendant's challenge to the aggravating circumstances for count one, so it's aggravated murder, is based on his misrepresentation of both the evidentiary standard at the preliminary hearing and the test for establishing the aggravated circumstances. As for the evidentiary standard, defendant erroneously asserts a magistrate, so the judge, engages in speculation when he chooses between a reasonable inference, which supports guilt, and a competing innocent inference. That is not at all what the defense was arguing, and we'll go through that. Remember that this is just their introduction. They say the Utah Supreme Court has rejected this logic and has repeatedly recognized this. This is not true. They take it out of context and they run the other direction. What they really did that I've noticed, the overwhelming takeaway for me from their reply brief is that they didn't acknowledge how what they're asking the court to do is speculate, or even argue how the inferences that they're asking the court to draw are reasonable. Instead, they run a completely different direction, and we'll see that in just a second. Okay. All right. Defense counsel ignores this controlling case law. No, they actually didn't. And have therefore violated their ethical duty of candor to the court. Whatever. Okay, that's not true. And I had a lot of stuff written here, but I backspaced it because we're just working off the reply brief. But I think when you're talking about duty of candor and obeying the court, like the fact that they introduced in their initial brief the pieces from the autopsy that the court had ordered them to not, that piece of evidence could not be published whatsoever, but whatever, that's for another day. All right. So, yeah. And not to mention that I have here that the prosecution cited the case law from other jurisdictions. Primarily, y'all, if you weren't in here the other night, they cite to so many out of state cases, and primarily from Pennsylvania, which no longer has a death penalty. Okay, so they say, contrary to the defendant's arguments, these cases establish when a fact finder chooses between reasonable inferences at trial, it is properly fulfilling its fact finding role. But we're talking about that's jury lingo, y'all, not speculating. Thus, even at trial, a fact finder is free to choose between reasonable inferences. Nobody's arguing that the jury is free to choose between reasonable inferences. It's just that their standard here is off. It's very off. So I write here, they're referring to a jury's right to weigh the evidence, right? That's not the judge for the judge to decide. But they're supposed to weigh it from reasonable inferences that can be drawn. Like anything that's not reasonable should not be considered. And I say here the prosecution fails to counter the defense's argument that some of the inferences are not reasonable. Okay, so they go on to say this is a preliminary hearing where this court does not sit as a fact finder. I say exactly. And then they just go on to say that the court has a duty to draw all reasonable inferences in the state's favor. Like, yeah. So I say here, I don't disagree with the standard of the court reviewing like reasonable inferences in the light most favorable to the state. That's fine. And we'll get into this. This is still just their introduction. Okay, so as for the great risk of death aggravating factor, they say defendant erroneously maintains the test for establishing this factor depends on the presence of some minimum number of facts or circumstances. They say the Utah Supreme Court has expressly disavowed such an analysis. That is not true. Instead, the governing test is the one the statute provides, whether a defendant knowingly caused a great risk of death to another. This one really blows my mind because what they're saying is that the test is just the statute. And the statute is what I showed you guys earlier whenever, the slides that show like murder versus aggravating murder. That's the statute. But the way we interpret a statute is by case law in that state weighing in on it, like, oh, this is what the aggravating factor means. And I say here, the governing test is a statute as interpreted through Utah case law. So it's crazy to me that they're just saying that it's just a statute. The Utah Supreme Court has not disavowed any such analysis. It simply leaves it to interpretation, right, as held in other Utah cases. Okay. All right. So this is just like the last page on their introduction. Thank goodness. So they go on to say the evidence here establishes at least probable cause that defendant did this when he intentionally fired his grandfather's high-powered rifle towards a crowd of thousands, several of whom were in the line of fire, while others were in close proximity to Charlie. Let's see. Indeed, the evidence is more than sufficient to support a finding beyond reasonable doubt. I don't even know why they bring up the standard for the jury to convict, because the standard here is a finding of probable cause as to whether the prosecution has met their prima facie case, right? Based on reasonable inferences before the court. So great that it could support a finding beyond reasonable doubt, but that's not what we're here to talk about. That doesn't matter. Okay. Let's see. So the rest of that on page 3, essentially we're not going to cover that. We're just going to talk about count 1 today. Okay. So let me check in the chat. How are you guys doing? Y'all have any questions? I know we've been over that a bit with the foundational work there. I'm just scrolling through here to see if anybody has anything that they want to add. But if not, that's cool because Christy, welcome in. So glad you could be here. All right. Does different case law hold different weight? That's Honeybee is asking that. So it's not that one court's ruling holds more than another unless it has overturned it, which is one of their arguments here. Case law is case law, both equally as good as long until it gets appealed or something like that. But no, as long as it's good case law in the state of Utah, 3, 4, 5 different cases, as long as they're not in conflict, then they hold the same weight. Sola scripture applied to criminal law. Yeah. Hey, Iodine, welcome in. All right, let's see. Tyler says it was Lance. What would happen? Well, we might find out. Hey, Green of 9, welcome in. Okay. No, Kathy, if he were going to say that it was Lance, it would be at trial, right? Because this right here, it wouldn't matter if he had said it at the preliminary hearing. It wouldn't matter. That's how extreme this is. The judge has to say, okay, as long as your evidence is reasonable, then we're going to take it at its face value and consider it true. But not for the sake of, convicting someone, but just have y'all gotten over the hump? And then if yes, y'all can battle it out in trial. Yeah, the statute must have precedent. So yeah, exactly. So the state legislature is the one who drafts this. And then every single time there's a case that the statute is, used in, then they do their own interpretation of it. And either that, the judge rules in favor or not. That's right. Like case precedent is how it's interpreted. So it's ridiculous for them to say that the standard is the statute. I was surprised to hear that. Okay, so let's go ahead and start another section. And yeah, it does get a little cerebral, so I will try to make this as painless as possible. All right. So this is their first argument, and they say defendant misrepresents the governing evidentiary standard because he relies on erroneous distinction between inferences and speculation that the Utah Supreme Court has rejected. Okay. So basically, they're saying that some of the case law, one tiny little piece of case law that the defense used, I mean, barely, and not even in the same context, doesn't work, right? Because it's been overruled, but it's only been overruled in part, and there's context to it. Okay. So they say that the Supreme Court explained in Ashcroft, that is another case. When a jury chooses between reasonable inferences to reach its verdict, it does not engage in speculation. But that's like not even what we're talking about here. They are running down the wrong path. They're not talking about what they should be talking about, which is reasonable inferences. That was the whole crux of the defense's opposition, right? So we go down a little bit here. They say because he ignores, and I copied and pasted this from the brief just to make it more aesthetic for you guys because there's a lot going on here. I took out as many of the citations as I could. And of course, what's in red is me. Okay. So they say because he ignores case law, which rejects the logic on which his argument depends, defendant erroneously labels as speculation many of the state's arguments about the evidence and the reasonable inferences this court court must draw. Okay. For example, although they say that evidence demonstrates a clear line of sight existed between defendant Sniper Perch and Charlie's seat, and others were near Charlie when defendant fired the fatal shot, defendant asserts this court would be engaging in speculation to infer from this evidence that defendant actually observed security personnel or other people. Yeah, actually, that is what the defense is saying. So in red, this is what I lifted from our earlier presentation, and this is exactly what the defense said. The issue here is not about what happens at trial, okay? Like in these cases that they are trying to talk about here, it's that at trial there was a conviction and the defendant went up on appeal and said, hey, the jury didn't consider like this other reasonable inference, right? It's up to the jury to decide once the evidence is there. It's up for the jury, but that's not even the issue here. Here, we're talking about reasonable inference versus speculation. Okay, so I have here, and this is what the defense is saying. The state makes little effort to distinguish between the evidence it presented and inferences it asks this court to make. Rather, the state pursues an unconstitutional expansion of the KGRD aggravators, that's the known greater risk of death aggravator, and fails to distinguish reasonable inference from speculation, right? So in this whole reply, it's almost as if the prosecution completely misses the point. This was pulled from the defense's opposition, right? They cite to a case from earlier this year from Murphy, and it says a magistrate may deny bind over, so saying like we're not going to trial, when the evidence considered under the totality of the circumstances, right? Considering everything together, judge, is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. In other words, a magistrate may properly deny going to trial where the facts presented by the prosecution provide no more than a basis for speculation. Murphy law, don't do that in here. Oh man, no, surely not. Maybe it was Murphy's law. All right, so still this part in red is still what I pulled from the defense opposition. So they go on to say, while the line separating speculation, which is just guessing, right, from reasonable inference can at times be faint. So they admit that. Sometimes it's a faint line, right? But the two are distinct. There's a distinction. An inference is a conclusion reached by considering other facts and deducing a logical sequence from them. Whereas speculation, just guessing, entails the act or practice of theorizing about matters over which there's no certain knowledge at hand, right? Okay. So in short, the difference between these two really depends on what the underlying evidence is. Okay, and then they go on to say, furthermore, it is not appropriate to stack inference upon inference. Just not. And this is where they cite from Cristobal. And this is where the I think really the prosecution is grasping at straws in their reply brief, because they take one piece of this and run with it without even acknowledging everything else. Okay. So while inferences drawn from facts and evidence are appropriate, inferences drawn from other inferences are not. Cristobal. That is still good law. Okay. They say, when evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. That has been, I'll call it overturned. They've overruled that, but that is a secondary part. And that is what the prosecution runs with. And I'm telling you, look, you guys, this is the table of authorities for, this is the table of authorities for the defense's opposition. Like, can y'all see how many are here? Look at all that. There's a second page too. Actually, there's 3. There are 3 pages here. And they decide to run with this secondary part without even acknowledging the good law. Okay. So then I have the following as a recitation of the evidence presented. And that was what the defense had done. And I actually clipped it out of here. So the defense, and I always think it's Kathy Nestor who did this. And it could have been any of them. They are talented defense attorneys. After reading all this stuff, I have way more faith in them than I did before. But anyways, what they say is this is the evidence that the state presented at trial that do not require an inference to be drawn. And like I said, I didn't include it here because it's a long list and it's factual, objective evidence. Okay. So moving down, this would be on page 4 of the reply, right? So they say similarly, although evidence shows defendant loaded his rifle with 4 cartridges and had previously done some target practice where he seldom hit the bullseye and sometimes missed the target completely, defendant asserts it would be speculative to infer that he knew he might miss his target. I agree with the defense on this. Okay, so I pulled from, so that we didn't have to redo some of our work and so that it looked familiar to some of y'all, our chart here. So the gray part is what they're saying. They're saying that the shooter knew he may hit someone other than the intended target because there were 4 cartridges found in his rifle. And the state, the next block down is what they actually said. So they're saying that it created a reasonable inference he anticipated his first shot might miss. Had he been certain of his aim, he would have no reason to load it with more than 1 bullet. But defendant was aware he might miss his target, thereby putting others in danger, both those in the line of fire and others nearby. And the state just says the defense just says, they're asking you to speculate about his knowledge. Like he was creating a high probability someone else could be killed because it had more than 1 round in it. And they say this is a circumstance in which the state cannot prove one inference is more likely than the other. But also, and they go on, it's really what it is it's building one inference upon another. And they say the facts are that the shooter did not miss his intended target and did not chamber another round. Those are the facts. He only shot 1. Okay. And then more on the speculation. Okay, so here the state is asking the court to draw a reasonable inference that he would hit someone other than Charlie, because targets, those paper targets, the target practice, those paper targets were found with bullet holes in them at his apartment. The state says defendant's target practice before shooting shows he did not always hit the bullseye. Indeed, some of his shots completely missed the target. And the defense is just like, this is ridiculous. This court cannot reasonably infer that Tyler's alleged use of the targets at some point in time in the past with some unknown weapon led to such knowledge on his part. They state that prosecution presented no evidence of when the targets were used, what weapon was used, the condition under which the targets were used, or even that he was alone in shooting the targets, or even that they were his, honestly. Without, any evidence tying the targets to the seized weapons, the relevant time frame and conditions under which the targets were used, the targets are not a basis for any reasonable inference about the shooter's state of mind. So let's pause there and see what y'all think. Any idea? I mean, I think that I think more than anything, the target practice argument is ridiculous. Yeah, it is a lot like the Karen Reed case. Yeah, it's absurd to assume if he missed, it would lead to the injury. Yeah, exactly. You are drawing an unreasonable inference because he hit it. He only fired one shot, and he hit. So, I mean, remember, you guys, I don't actually think this is how it all went down, but I'm just saying, like, this is what we're up against, so this is what we have to address. Let me see what y'all think about the target practice. Yeah, foundation must not be speculative. And this is, I mean, the target practice one is even more so than the multiple rounds. But even the multiple rounds, that's insane. That is an insane inference to draw. Well, we know he didn't shoot anything, Casey, I know. I think it is an immunity deal. Yes, and I do think prosecutors are playing games. Yes, I absolutely do. So sets of inductive reasoning cannot be compounded, but those established by deduction. Yeah. Oh, yeah, Green of 9. This is such a weak case. I cannot believe that this is the state of Utah. The state of Utah putting this on. Like, I cannot imagine. This is like the highest, not the highest court, but I mean, this is the prosecutor of the state grasping at straws, saying that these targets that they recovered from his apartment, that they don't even know are his. They don't even know if he is the only one who shot it. Like, they didn't lay, it wasn't enough to just bring in just the targets. Also, you know, they barely even talked about the targets in the preliminary hearing. It's not like, okay, I know the bar is really low, but you have to do something to substantiate your evidence. They didn't even, of course they didn't cross-examine it. Like, they didn't even establish that these were his or the rest of what the defense is arguing here. I'm just reading through some of y'all's comments to see, because I know it's a lot. It's a mouthful. So, oh, wait, it gets better, y'all. It just gets better. I think they didn't intend Tyler to live. So that's why I think this is why I think that they're grasping at straws, because they have nothing. I don't think that the judge is corrupt. I haven't seen that yet. And so. Yeah, targets are ridiculous, and it also shows he's not a great shot. Well, that's what they're saying, is that he's not a great shot, but the fact is that the defense says you don't even know that these are his, or that he was the only one shooting them, or that, like, or when this was done. This could have been done 5 years ago, technically. Really could have, or 10 years ago. Maybe it was like his first time going to the range, and he's a way better marksman now. Yeah, why are they there? Unless it, Justin, unless it is what I just said, and maybe that was the first time he went shooting. But he comes from a family of hunters. Yeah, the validity of them even being there in the first place. Yeah, I agree. He was supposed to be eliminated, green a 9. I agree. So we would never notice how bad. Yeah, exactly. They did not expect to have to put on evidence for trial. Is basically what I'm gathering. You would think if you were planning something, yeah, right. I know. Kez is right. If you were planning something, you would cover all possibilities, including that he might live. Right. I only bring targets home if they're good. And then I'm like, okay. Then I go through one of my phases where I'm cleaning everything out and I'm like, why did I bring this home? Okay. Okay, so let's get on through this. All right. So this is when they just rail on about Cristobal. Let's see. And that defendant asserts when evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. So that is overturned, but that is not. And yes, they did clip that in here. They did put that in here, but that is not their main argument. But this is exactly this is all the defense runs with, is this part right here. They don't address the relevant issue, which is there evidence? Could it create a reasonable inference, right? Okay, so yeah, the Court of Appeals has expressly and repeatedly recognized these cases make clear that choosing between competing reasonable inferences is not speculation, but what a jury must do. Exactly. Like that's not even what the defense was really arguing. And what I should have highlighted and read here is that we're not talking about overturning a jury verdict. The defense presented the correct standard for what speculation versus reasonable inferences, like we saw. Let me go back. This up here at the top, this is all good law. Even that bolded section from Cristobal is still good. And they've established, when we get down here, you'll see the Salt Lake City citation. The prosecution cites that too. It's good law. So here I say the defense presented the correct standard for speculation versus reasonable inference for the judge, right? Okay, so they go on. The defendant in Ashcraft argued the existence of innocent inferences. They're just talking about the defendant there arguing that the jury engaged in speculation, but it's like irrelevant here. So let's just keep going. Okay. So they go on and on about Ashcraft, saying that equally plausible alternative inferences is not enough to set aside a jury verdict. But we're not freaking talking about that. Let's see. Right. So they just keep on going down this path. More than one alternate reasonable hypothesis does not necessarily prevent the jury from concluding that a defendant is guilty beyond a reasonable doubt. We know that is like not what the defense's argument is here. Let's see. I'm only going to throw at you guys what is actually relevant to this. Yeah. So the next paragraph down, I just want to reiterate, all they do is talk about Ashcraft in that one little clip from Cristobal. And I just say again, we aren't talking about equally plausible alternative inferences that are drawn by the jury or setting aside a jury verdict. The defense is saying that the state is asking this court to speculate. And the prosecution does not do a good job in this reply even talking about that whatsoever. Okay. So they go on to say, if the existence existence of alternative inferences, and I interject here saying that the standard is alternative reasonable inferences, right? They say if it's not enough to justify setting aside a jury verdict of guilt, then it's not enough to deny binding over preliminary hearing. Basically, they go on to say magistrate must view all evidence in light most favorable to the prosecution and draw all reasonable, once again, I highlight that, inferences in favor of the prosecution. Nobody disagrees with that. And at the preliminary hearing, the prosecution is not required to eliminate alternative inferences that could be drawn from the evidence in favor of the defense. That's not what the defense is arguing. Okay. So then they go on to say, while viewing all reasonable inferences in the state's favor at the preliminary hearing is not speculation, it is precisely what the law requires, the court to do. Yeah. But they say that the defendant's argument is based on overruled case law, and they just keep on about this Ashcraft thing. And it's like, that's not what the argument was. They don't talk about how their evidence is reasonable whatsoever. And that's what we're arguing here. And then I say here, I should have put more of it in red, but I said Cristobal is not overturned with respect to the defense's argument. While inferences drawn from facts are appropriate, inferences drawn from inferences are not, right? So the part of the Cristobal law that is overturned is irrelevant to the defense's argument. All right. So then they go on to say, moreover, an inference is reasonable as opposed to speculative when it's based on evidence. And I say, yeah, but to support the conclusion. It's not just based on evidence. And they go on to say exactly what we did earlier, right? And what I just included right down here again is that there's a faint line between speculation and reasonable evidence. And they say, well, in the case of speculation, there's no underlying evidence to support the conclusion. Yeah, I agree with you there. And then they say, thus, a reasonable inferences not amounting to speculation is a conclusion reached by considering other facts and deducting a logical consequence from them. Okay, cool. Thanks for giving us the law. And I said they're quoting Salt Lake City, which we did too. Okay, great. Thank you for giving us the law, but can you argue your facts? And then they go on to say, as the state's opening memo demonstrates and is further detailed below, all the inferences the state has identified are grounded in the evidence. They are not speculative, and they support bind over on all counts. And I won't read it to you guys again. I just included it because it was important here. This is just copy and pasted again about what is speculation and what is reasonable inference. Okay. So what do y'all think about that? We do have more. It does get better with the with the speculation and what they're trying to argue here. We'll get to the scope stuff. Yeah, he could have been throwing pencils at the targets. Or I don't know, maybe it was something he did with a girlfriend and he just wanted to save him. It is just wild to draw those conclusions. Or inferences, excuse me. Okay. I'm just seeing if y'all have anything before we go on. I know it's very doctrinal. Yeah. Oh yeah. The prosecution is playing games. I have a whole new theory on what's happening here. I really think they are trying to throw the case on purpose. I think that they are purposely not making good arguments, to be completely honest with you. Yeah, they sound confused. Right. You're not confused. You are not confused. They are confused. And it's interesting because the prosecutor, the lead prosecutor on our case, was the prosecutor in some of these cases that overturned the Cristobal case. So out of all attorneys who would know what it really meant. Okay. So let me crack this open. Okay. Polishing my burner. Okay. So let's do this one. Y'all are doing really good too. So thanks for, you guys are, this is the court of public opinion and y'all are the jurors. All right. So this last bit here, we're going to get to more fun stuff. Okay. So their second argument, right? They didn't really make a good first argument, did they? They did not. If you didn't know the answer, they did not. Okay. So their second argument is, when properly construed, the evidence that the prosecution, presented demonstrates a reasonable belief that Tyler knowingly created a great risk of death to another. All right. They're saying, and so now they're starting to attack the defendant's interpretation of the statute. So the reasonable case law that defense used, and we're going to go over it in a minute. Some of y'all have already seen it. They, instead of, because apparently the prosecution thinks it's just the statute that is what is supposed to be used. Okay, so they say it does not require a minimum of factual circumstances, nor is it a multi-factor test. Let's see. And they just say, basically, we've met the standard. And this is when they get into Sosa Heredio. Let me see if I want to do this first. I'll read this to you guys first, and then we'll go through the actual case law that we have. Okay. So in 2019, Utah revisited the interpretation of aggravated murder. It had twice been touched upon by two other courts in Utah. Obviously, this is precedential law. What the 2019, I'm going to call it the SH. Let's just call it Sosa. What the Sosa court ended up coming up with was, hey, look, the precedential law is good here. We are not going to, establish new law, because a court doesn't want to establish new law. All right. Like if the existing law is good and narrowly tailored, they're going to say, okay, we're looking at it through the precedent. This is good. It's pivotal when a court, especially a Supreme Court, further interprets a statute or overrules something. So yeah, the Sosa court in 2019 says, hey, the earlier cases, one's name, like they have their names, Johnson and Pierre. All right. They're good. But the prosecution here says that the ultimate test is the statutory test. And it just requires that the defendant knowingly created the great risk of death. What lawyer wrote this? like, it's not just the statute. It is precedential case law. And here I have, and we're going to go through it. SOSA relies on and endorses the case law interpreting the GKRD aggravator, right? Am I even on the right one with y'all? Yeah. The case law interpreting this in Utah, as discussed in Pierre and Johnson. It does not seek to establish new law. They're just saying, hey, yeah, this looks good. Okay, so then they say the 3 factors in SOSA that the court identified to guide the application of the statutory test are simply a range of factors, right? Of possible relevance to interpreting the statute. They contradict themselves a lot. Like, if you're confused and you sit here and you're like, okay, wait, what? It's always good to reread it, but you're not always wrong. And I have here, okay, a range of factors of possible relevance to the statutory inquiry as elaborated in our case law. And I say exactly, like literally exactly. You guys just said the opposite of that. In fact, the court repeated, we are not here establishing a multi-factor test. That's fine. The considerations in SOSA are not exhaustive, and they are not the test. They say that defendant ignores these portions. That's not at all what happens. The court upheld the existing law. Okay. They also say that defendant also erroneously argues this court to construe the aggravating circumstances narrowly. Yes, that it's constitutionally required, as we'll see in just a second. I cannot believe they said this. The legislature has already narrowed the aggravator, right? Exactly. That is, well, no, the legislature did not narrowly tailor the law just by the statute alone. They narrowly tailored it by the case law. And essentially, the defense is saying, prosecution is asking you guys to expand this law, which is the opposite direction of what we're supposed to be doing here. It's a constitutional violation. Okay, so they go on to say this court cannot apply its own narrowing gloss to that standard. Okay, whatever. And the ultimate test is a statutory test. I say this is entirely incorrect. We're going to look at the constitutional argument raised by the defense in just a second. They go on to say, nor does the defendant's emphasis on language from other cases, that a defendant must create a high probability of death, modify the statutory standard. A high probability of death is just another way to say great risk of death. Yeah, okay. It's the same. Like, what are they even arguing here? Other courts use the term high probability. Other courts' use of the term high probability, therefore, does not modify this statutory endorsement. We're not asking for a modification here. And in a minute, we're gonna go over this case law so that y'all know where we're going here. But let's get through this first. They say it also makes no difference that facts of other cases do not precisely fit the facts here. Well, I will say this. They don't have to fit perfectly, but they're very different. They are very different. Defendant spills much ink detailing the facts of other cases. This is where they get a little too arrogant, where courts have analyzed the aggravating factor. But the fact other defendants did more to endanger others, like firing multiple shots than Tyler, is not persuasive. I would argue, yes, it is, actually. They say the issue is not whether another court has applied the aggravator in a case with identical or at least similar facts. That's like, yeah. But the issue is whether the evidence, together with the reasonable inferences, support a reasonable belief that defendant knowingly created a great risk of death to at least one other person. The state has comfortably surmounted that low bar. I totally disagree. Okay, and hang in there for just a minute. We're almost done with this portion. they go on to say the court must recognize that while Sosa analyzed and applied the aggravator, it did so in a different context. Yeah, it did. But it can still, it's still applicable here. It is the law on the aggravator, right? And therefore had a different focus. Okay. And they go on to talk about how, and I'm not going to read that to you right here because we're about to go over it, but you'll see what the standard in Utah is. Okay. And then they say the court ultimately held the relevant circumstances include more than just the murderous act itself. All right. A person may be guilty of knowingly creating great risk of death to another if he did so within a brief span of time of the act causing the murder and the acts together forming a concatenating a series of events. Y'all who are in here know about that. So unlike Sosa, they say this case only involves the murderous act itself. So are you totally discounting? You're just saying the murderous act itself. So you are contradicting yourself because you're wanting us to bring in all the other inferences that you're saying. And the established case law is that speculation versus reasonable inference is the circumstance of all the evidence, right? So I say here, so prosecution is saying we shouldn't look at the relevant circumstances. Okay, so let me go ahead and put up the case law because it'll help. Okay. Also, this is very important to hit. You guys know about how they just said that, like, the defense is wanting this to be narrowly tailored. Well, yeah, because that is an 8th and 14th Amendment, like, constitutional protection. And this is what the defense cited in their brief. They said 18th and 14th Amendments to the U.S. Constitution do not permit the imposition of the death penalty in an arbitrary or capricious manner. The objective of the law is to require discretion in a capital case to be tailored to a reasonable distinction between cases in which the death penalty is imposed and those in which it's not. Like, it's supposed to be very narrowly tailored. The principle that the death penalty may not be wantonly and freakishly imposed requires a state to provide specific detailed guidance, right? The Constitution requires courts to narrowly construe aggravating factors to, obviously avoid overly broad interpretations, right? And it's like, how did a prosecutor just write that it's erroneous for the defense to want this to be narrowly tailored? Okay, and I will just briefly touch on this. So the defense cited to twice in history were SCOTUS, so that's the Supreme Court of the United States, right? Because that's where this stuff goes. Looked at whether the state of Georgia and the state of Florida, whether their laws were not narrowly construed enough, right? And they ended up upholding both Georgia and Florida's laws by saying that, it was very specific. In fact, Georgia had only once upheld such a conviction, and this is where a man fired a gun indiscriminately into a church crowd. So you can see that's already different than what we have here. My point is that this is narrow. And let's see, that they had reversed a finding of it when a victim was just kidnapped in a parking lot. And then when they're talking about Florida, they said it was obvious because the defendant murdered 2 victims in order to avoid a surviving witness to the first murder. This is how narrowly tailored it should be. Okay. Let's see. All right. So that touches upon the constitutionality of it. I cannot believe that they wrote that. Now, go back with me. They're complaining about Sosa, right? And they're basically saying that Sosa is not establishing case law. No, they're not. They are actually just affirming and endorsing what had already been, set as precedent. So Sosa didn't add anything new. They just said whether the aggravator applies, is often influenced by three main factors. The chronological relationship between any actions the defendant may have towards the third party, the spatial relationship, meaning how close they are, and to what extent the third party was actually threatened, either by direct threats or indirect, by like stray or ricocheting bullets. So that's all that Sosa said. They just said, we're not going to create new law, but we're upholding this. Okay, and to show you guys exactly how specific this is, these are Utah laws. The prosecution in this case cited to, and they do it here, and we'll go over it in just a second. They cited to a ton of Pennsylvania law. I don't even know what they were doing there. Okay, but to show you guys where Utah has upheld this before. All right, and Pierre, he was convicted of 3 counts of capital murder when he and 2 co-defendants tied up 5 people and forced them all to drink liquid Drano. And then he shot them all in the head, right? 3 of them died, 2 of them lived. And the court finds the concatenating, that is never going to be a word I can say. I can say buccal. It's not buccal swabs. It's buccal. But basically a series of events where the acts are in the series are linked together in a meaningful way, right? This may be established based on the defendant's intent and knowledge of the risk and the endangered person's proximity in time and space. Okay, so in Utah, that is good law. That is where they have found it upheld. And then in Johnson, this is where they found it does not apply. Okay, let's see. Yeah, this was the shovel one. All right, so they say that the aggravating factor properly applies to situations in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. And in this case, they struck it down because the defendant attacked a husband and a wife with a shovel, but he killed the man when the man was on the other side of the warehouse from his wife, and there were shelves in between. The court said the state produced no evidence indicating that the wife was placed in a grave risk of death by defendant's battery of the husband, nor did it produce evidence indicating that the defendant even knew that his conduct towards the husband put the wife at great risk, right? So this is good law. I don't understand the prosecution here. Okay, and then we won't really go through this, but these are other instances in which the KGRD has been applied, and these are out of state, but the defense brought them in anyways. And in each, the defendant fired multiple shots from a firearm in close time and space to the other people who were injured. Other people, and each of these other people were injured. You've got one where he's firing multiple shots in a church, like indiscriminately. You have another where he shot his intended victims in a crowded bar where there were other people in the immediate area. And he wounded other people, right? Then you have where the defendant shot his victim in a crowded place of college students, and one of the shots wounded another student when he emptied his revolver. So every single bullet in there he used. And then in Louisiana, the execution of 2 victims lying side by side with 6 shots clearly, let's see. that's covering this up. Side by side with 6. Yeah, with 6 shots. Okay. Obviously, these are very narrowly tailored. This is why the Supreme Court has upheld these, and this is why this case law is good, at least in those other states. And Johnson cites them, right? So it's incorporated into the Utah law. Well, it's incorporated as being like persuasive, right? Let's see. Okay. And then a very important one that they cite is Price. And it says that to find this aggravating factor, there must be a likelihood or high probability of great risk of death created, not just a mere possibility, right? And then this is what happened in Sosa. Basically, defendant entered the shop. He was going after the son, right? But he fired at the dad who was standing behind the counter to get him away from the son so that he could shoot and kill the son. But he, in doing so, there was shattered glass and stuff that cut up and injured the dad. And then anyways, the defendant ends up shooting the son again, and it causes him to fall to the floor, and then he shoots him twice, killing him. So this was the 2019 case. And you can see why they upheld that. I mean, close proximity. There was an intent to, he didn't care if he harmed the dad. The point was to get the dad out of the way. I'm going to read that. Okay. So let's just take a little stop right there and see how you guys are doing. Yeah, the aggravated charge is so absurd according to Utah law. I agree. I totally agree with you. I'm glad you think so. Yeah, can't be wanton, freakishly wanton. The point is that the Supreme Court of the United States and the states that prosecute these, they say there has to be a huge distinction between the murder cases that are punishable by death and those that are not. And you can see why the defense used this blah blah blah. Why they use this law? This is Utah law, right? And essentially, the prosecution is saying no, that it doesn't fit because the facts are different. Well, there's a good argument to be had that in some of those there's not, because in one of them there was a bunch of college kids, right? And he's like indiscriminately shooting at everybody. And in each of these that they cite, there was somebody else who actually did get hurt. Therefore, there was another victim of battery. At least they didn't die. Some of them did. But you can see the egregiousness of those crimes compared to what we have here. And they have, although they argue this, that the facts are different, they don't specify. They don't use the facts of their case, really. They just say, they argue against the holding law without applying facts. Smoke Boy says no inference allowed. What does SCOTUS know? The pickle has spoken. I love that. Yeah, pure speculation based on the first hit. And nobody else was factually injured. And there was no second bullet. Maybe there could have been a case, the whole thing would be different if he shot on the first shot and hit, and then he fired another pointless round into the crowd. this is it. No, this is exactly why they were focused on the aggravated charge, because it makes the difference between the death penalty and 15 years to life in prison, which to me is an overkill because, no pun intended, these other cases, other people did get hurt, right? So yes, there was like a murder victim and then other people, it's not tantamount to death. They didn't die, but they could have, right? But here, that's not what we have. Like, why would this law be there if it didn't matter? Did someone say concatenating? Yes, Fillmore. Concatenating, right? Is that right? Honeybee, thank you. I appreciate you saying I'm sharp, because it does. It takes a lot of mental energy. You're talking about, like, I really think I probably burn as many calories thinking in my brain with this stuff as I do exercising sometimes. Hey, Lemon, welcome in. Yeah, they have to fit a square through a round hole. I mean, they are grasping at straws, y'all. Let's see. I'm just reading finishing up on these comments. You come to speak my legally, or to hear my legalese. Just give me a list of words you want me to say. I'll do it for you. We can do like a poem. We could do a haiku night. Yes, Green and 9, it makes a good point. All the cases I read off were very clear and concrete. And that is Utah law, you guys. If y'all missed the other one, we'll briefly go through it, but the number of cases that they cited to out of state is insane. Maybe we should post a guard at the door. Yeah. Yeah, my brain tuckers out too. I am very ADHD. Okay, Keza, thank you for being here. Really appreciate it. Have a good time with the dog. He didn't even rack another round. Right, that's a really good point too. He didn't even rack another round. Okay, that's a really good point. I like that. Okay, so let's get back to it. Back to our arguments here. Wait. Was it this one? Wait, remove this one. Okay, here we go. I'm glad y'all are keeping in pace. Look, we're almost there, y'all. We're almost there. Okay, so then they say, as if they're done with that argument, right? They're like done with that argument. Like, okay, we made our argument. Then they say the evidence supports a reasonable belief, the statutory test, right? So apparently not the case law for the great risk of death aggravator is satisfied here. They say that although Sosa was focused on the scope of the relevant circumstances, as it should be, to support the aggravator, its analysis is nevertheless helpful here because the Supreme Court recognized firing a rifle at a murder victim while another is close by creates a great risk of death to the surviving person. And I say here that is way too simplistic of an explanation, as we just saw. In Sosa, he literally shoots at the dad and it hits his hand, and like to get him out of the way of the son. Very close proximity, and he shoots him with disregard that it could hurt him, right? So it's wild. Okay. Let's see. As explained in the state's opening memo, Sosa court recognized there were two separate acts that created a great risk of death to the surviving smoke shop employee. Yeah. The first act was the shot fired towards that surviving one that missed. It was actually his dad, not just an employee. The other was a shot that hit the murder victim in the hand while the surviving employee was only a few feet away. So then they say, thus, contrary to defendant's contention, Utah has, in fact, adopted an interpretation of the factor which would permit its application where the firing of a single shot at an intended victim hit only the intended victim. No, I think that's insane, because he actually fired a shot at the dad. They get this wrong now that I'm like really reading it. Because where the firing of a single shot at intended. Yeah, no, they are so wrong here, you guys. We just went over this. Like, the guy in Sosa goes into the smoke shop. He had a beef with the son. Shoots at the dad, right? And it doesn't hit him, but it causes like glass and wood and all these shards to like really injure him a lot. Like, it just blasts it into his leg. And then he shoots the son. But there wasn't a single shot. There was more than one. They're crazy. This is wild. I am now sitting here like really reading it. I mean, listen, I've read it. But now that we're working through it together, I wasn't out of my mind when I got angry earlier. It's been a long day. Okay. So they say here, there were several people close to Charlie when defendant shot him dead. Not like Sosa, okay? Most significantly, the questioner, so that'd be Hunter Kozak, was directly between defendant and Charlie, within a few feet of Charlie. There were also several people near Hunter Kozak. There were also those with Charlie who were under or near his tent. All these people were visible in the clear line of sight between defendant's perch. What is he, a bird? I don't know, whatever. And Mr. Kirk. Indeed, from a distance at 410 feet. And then some of what they've said, I've highlighted in red. They say basic mathematics dictates an angular shift of even 1/8 of an inch would result in a substantial miss of the intended target, either above, below, left, right, depending on the direction of the shift, placing many others in danger. And then I added here, you cannot introduce new evidence. They did not introduce that evidence. That cannot be considered. Because you could say, oh, well, it's reasonable to think that a shift of even 1/8 of an inch would have resulted in, but it's not proper. It's not proper. You can't introduce new evidence. Like, once you've gone to your preliminary hearing and you've made your brief, and if you're the first one, you're what we call the moving party. And then you get an opposition. You can't introduce new stuff. This is scientific stuff. This is expert witness testimony that they didn't give. Okay. And then they say, given these facts, 2 of the 3 Sosa factors support the conclusion that it applies. This is just such a waste of time for anyone to have to bite. They're saying the spatial relationship is close. This is not, like someone said in the chat, like, the Utah law is extremely detailed on what is close spatial relationship. And that, let's see, defendant also threatens them by indirect means through the risk of stray or ricocheting bullets. What ricocheting bullets? What stray? Like, he only shot one shot. They say that the time between the murderous act and any other acts the defendant may have taken towards third parties is simply inapplicable here, because it didn't happen. Let's see. So they're saying that basically Sosa supports them, that Tyler created a known risk of death to others. Okay. All right. So then they do this whole line of fire crap. So they talk about how defendant attacks the state's line of fire argument, which he repeatedly mislabels as line of sight. Well, that's because that is what the prosecution labeled it as, line of sight. They kept saying line of sight. And they bring up the fact that defendant says that the bullet traveled above, not through the crowd. But then they say in the state's Exhibit 8 that Hunter Kozak's head is visible above Charlie's head, and others standing in the front row of the crowd are positioned at approximately the same level as Kozak, but slightly further back. They are reaching so hard. And regardless of the precise elevation of Hunter's head and the heads of others in the crowd in relation to Charlie's head, any difference is so negligible that it does not place these others outside the line of fire. Okay. I mean, it was very specific. Obviously, there was a scope. It was a direct hit. Okay, let's see. So they say that, oh, here we go. Now they're starting to quote outside state law because Utah law does not support this. The evidence, therefore, supports a reasonable belief that these people were in the line of fire and therefore within a zone of danger. And they quote Florida law about the line of fire. And they also start to quote, they go back to quoting Pennsylvania, which, reminder, Pennsylvania no longer has the death penalty. So let me show you guys that. It's important. We won't take long. But since we already, let's see, where is it? Oh no, here it is. Okay. I thought maybe. All right. So this was from the defense's brief, right? So they're saying basically what prosecution is saying here. They say that the state attempts to claim Sosa establishes firing a gun at one person can create a great risk of death to others who are near, even if they are not within the line of fire. They say Utah has never adopted an interpretation of this where it would permit the aggravating factor where the firing of a single shot at an intended victim hit only the intended victim merely because other people were in the vicinity. So they say, as a matter of law, the court cannot bind this over on the theory of the aggravator because the evidence presented by the prosecution does not satisfy these factors. And then here we get into it. This is why I pulled this up, to show you guys how desperate the prosecution is to support their arguments, because they don't have any Utah case law to support this. So it says, nor does the state's reliance on out-of-state authorities in which persons other than the decedent are targeted or injured support this proposition. So here we go. I won't read this all to you, but basically they cite to Pennsylvania, which doesn't even have its own death penalty anymore, Florida and Arizona. Every case involves conduct directed at the endangered person, not the murder victim, right? So even at that, like, these cases are different. Okay. So I just want to show you guys how many. These are all pulled from the prosecution's initial brief. So you have 1, 2, 3, 4. Yeah, more than that. There's more than that. But let's see here. All right, let's see. I'll just quickly tell you what happened in these. So defendant fired and hit the victim, who fell and tried to get up. He fired 3 more shots. Each of them hit the victim, and the last one passed through and ricocheted off of a solid surface. That's awful. Before hitting him again. There were several people on the porch very close. But I mean, here you do have like ricocheting bullets and multiple shots, right? Okay. Then in another case, And remember, these are all Pennsylvania cases, and Pennsylvania doesn't even have the death penalty right now. So in Watson, the defendant was found to, have posed a great risk of death to others when he pulled his ex-girlfriend from a closet where she was hiding with her 2 kids, and he shot her. One of the shots lodged into the door frame around the closet where the kids were hiding but didn't hit them. And the children were found to be in line of fire. I agree with that. Then in Lye, 3 defendants with multiple firearms shot a victim in the head while her sister was standing directly next to her. I mean, obviously that bullet could have gone straight through. And then in Reed chased kids in his vehicle down the street, fired multiple shots at random, killed a boy, and then a week later he did it again, killing another boy. So they're saying like all the boys there were in the line of fire. I mean, he was indiscriminately shooting, right? So even if you wanted to look at these cases, they're not within our jurisdiction. This jurisdiction doesn't even have the death penalty anymore, and they're totally different. And then they have another one, and another one. Oh, and here 3 more. Rios, where the defendants went into a house to rob it. There were 4 victims. Each was forced to lay down in a single bedroom. 1 was shot and killed. 2 were beaten. They used multiple firearms. They found the aggravating factor because the fatal shot was fired while the victim was laying on the floor with a second person on the floor nearby, obviously, and the other 2 were on the bed. And Buck, which they just cited to here, while only 1 person was shot and killed, the potentially endangered person stood behind the victim in a bathroom. And because the endangered person wrestled with the defendant over the gun after the shot was fired. So clearly that's in the line of fire. And another one, the defendant broke into a very small bedroom, swinging his gun loaded, and then put his gun to the victim's head. Then he found the victim and killed him. 3 shots went through him. 1 was never recovered, shell casings everywhere, and there was a kid on the bed, only a few feet away. And then, of course, Silva v. Florida. And we won't read it because I've put y'all through enough already. Okay. What do y'all think? Any thoughts right now? We're almost done. Turn this guy's. Yeah, KZ, I saw that same thing. The drone I saw was the size of a palm, and it is very capable of shooting lethal projectiles. I'm seeing if y'all said anything. If that judge is a magistrate, they don't even have to have a law degree or pass the bar or have a college degree of any kind. They do here. I don't know. I'm not seeing the whole comment. Hey, Trash, welcome in. Y'all have done really, really good. I appreciate everybody hanging out because I know this is a lot. Oh, Crunk, I hope you feel better. Okay. Hi, Moose. Oh, they're definitely reaching, yeah. Yeah, I know it's a lot. It's a lot to take in, but we're almost done. Yeah, there's no case law to support their arguments. Absolutely not. Good, Mr. Feelgood. That's what I aim for, is so that y'all leave with some more information, learning something, obviously, because this part is difficult when we're all watching this and we have no idea how to interpret it. Yeah, it's a stretch. Okay, so let's finish up my on argument 2. Move from stage, add to stage. Look at that. All right, so I just showed you guys. Yeah, and we can see here the bottom where I have it highlighted in red on the bottom. Those are some of the cases that they relied on originally, and they continue to rely on them here. All right. So this would be on page 11 of their brief, right? So then they go on. They don't make any further argument there. They're really, it's rough. I will say this: they had to argue something. So I mean, I'll give them that. They had to argue something. They can't just not argue at all. But if it's this bad, do you have probable cause to bring this against this boy? I don't know. I think it's egregious. Okay, so then they go on to say that he created a great risk of death to those near Charlie when he pulled the trigger, even though they were not in the line of fire. Oh, this is where our arguments start to, yeah, y'all are going to see this. Okay. 2 security personnel were directly in front and on either side of Charlie, still under his tent. A 3rd security person was under the tent, and this person only had to take a small step to reach Charlie when he fell. Another person was operating a camera. Okay, we know who that is. And defendant had a clear line of sight to all these people. So they also said the evidence supports reasonable inference. Defendant knew. Okay, I know why I highlighted this. People were in the area behind Charlie's tent. Okay, let me read that again because that's insane. This is what they wrote. I just highlighted it in red because it was just so wild. The evidence also supports a reasonable inference. Defendant knew people were in the area behind Charlie's tent. Do you guys remember Agent Hull saying there wasn't anybody behind there? Do you guys remember Kathy Nestor asking him? And everybody was like, I wonder why she's asking him that. Well, defense included that in their brief, saying Hull said there was nobody even there. So they go on to say that because defendant visited the amphitheater at least twice before the shooting, we know it was like hours before, based on what they're saying, like 3.5 hours. This evidence supports a reasonable inference. He saw the staging area behind Charlie's tent, and the fact that he had a clear line of sight to Charlie's tent at the time of shooting also supports a reasonable inference. He knew people were in that staging area when he fired. Like, they talk about, there was nobody even behind the tent. She pulled that out of the testimony to put in their brief. And then they go on. Defendant argues that given the speed with which he had to acquire his target and fire once he got into the position in the sniper's nest, that the evidence does not support a reasonable inference. He knew that any of these people were present. Yeah, that's what the defense said. It's like, you guys said he literally had 35 to 44 seconds. That's what you guys said. And y'all are also saying that he had to put together his gun and that, get it all set up, and that the scope was probably off. But y'all are also saying that he saw other people through his scope, essentially. And then they just go on to say that he had a clear line of sight. We'll see. They also said that defendant had longer than just 35 to 44 seconds in the prone position to observe people. Because this is what they wrote. I did not add this in. He would have seen these people as he ran across the roof and then crawled towards his position. So he had extra time, you guys. Yeah, okay. So then they say, regardless, emphasizing how hastily defendant had to act to acquire his target and fire his rifle does not help him. It only highlights and increases the likelihood he would miss his intended target. Okay, but he didn't. The speed with which defendant had to act, coupled with evidence showing he had to reassemble his rifle, and that he loaded 4 cartridges, and in his earlier target practice, he sometimes missed the target entirely. I can't make this up. This is a state prosecutor that wrote this. This all supports a reasonable inference that he knew he could miss. Yeah, what about like those inferences upon inferences, they say that this supports a reasonable belief. He knowingly created a great risk of death to those in his line of fire. And then they go on to not support it with a Utah case law, but one of the ones I just read to you from Pennsylvania. Okay. All right. So we're gearing towards the end, but it gets a little bit more fun. All right. So then they say common sense dictates that firing a gun towards others puts them at a great risk of death. And then they cite Provo shooting sports range safety rules. You can't introduce new evidence. It says this is precisely why gun ranges prohibit shooters from even handling a firearm when others are downrange beyond the firing line. Yeah, but like I cannot believe that they cited to Provo Sports Park range safety rules and included the link. Okay, I'll just let that speak for itself. All right. They go on to say defendant highlights cases where other courts did not find the facts satisfied the aggravator. But again, the issue is not how closely facts here resemble those in other cases. Yeah, actually, the circumstances do. The circumstances are relevant. The issue is whether here the facts, together with reasonable inferences, demonstrate reasonable belief defendant satisfied the statutory aggravator. And none of these cases resemble the scenario here. Yeah, exactly. None of them do. But the main takeaway is that we see what the court looks at and says, yes, this does satisfy it. And they're talking about the statutory aggravator. Yeah, I know it's statutory, but they don't cite to one freaking case in Utah that can support this. In fact, the out of court cases they cite to don't fit it either. So you know what? It's interesting that they say that none of the facts here match the cases that we presented, but none of the facts here match any of the cases they presented that were out of state. Okay, so this part down here is what I included from the analysis of the defendant's opposition, right? Just like we saw earlier. So it's got what the state is asking this court to speculate on, that he observed security personnel standing at an unknown distance from Charlie. And the state says he could see these people through his rifle scope. Like that's an inference. You're asking the judge to draw a reasonable inference that is the case, and that he was aware of the existing circumstances. Oh wait, I thought you guys didn't want to the only thing you're looking at here is just the murderous act itself. Y'all didn't like circumstances before. And then the defense says state's evidence shows that he was on the low-C roof in a prone position for 35 to 44 seconds before firing. According to state's evidence, this means the shooter had approximately 40 seconds after coming to arrest to ready their rifle, acquire the target with the scope, steady their breathing, and fire the weapon. The state also asked the court to speculate about what the shooter saw through the scope during this limited window of time while focusing on these tasks. However, one of the state's case agents, Agent Hull, testified he could not testify as to what the shooter saw. Indeed, the only reasonable inference from this limited time window and the fact that Charlie was shot was that he observed Charlie through his scope. I think that's fair. Okay. The shooter knew that he may strike someone other than the intended target because the rifle may have been taken apart and put back together. So the state says even if defendant had previously calibrated his rifle and scope, he had disassembled it to transport it to the roof undetected and then reassembled it on the rooftop using the screwdriver. They say a reasonable inference from these facts is the reassembled rifle would not be as accurate as previously when it was sighted in one piece. I mean, they must have had a round tabling, and this was like their best. I'll give it to them. I mean, it's like if you're scraping the bottom of the barrel, not bad, but it's not sufficient, right? So then the defense says, okay, this is in their brief. The state also asked the court to speculate that after scoping his rifle, it was taken apart and put back together prior to the shooting, right? And therefore, he knew that there was a lack of accuracy. And they say the state presented no evidence to support any inference the rifle was in pieces at any time. That's true. They never presented evidence that it was ever in pieces. She says the video evidence shows Mr. Robinson walking up and down stairs with a gait impaired and something long in his pant leg. The reasonable inference from the evidence provided is that it was a fully assembled rifle. The presence of a screwdriver on the roof does not establish that the rifle was taken apart and put back together, any more than it establishes a screwdriver was intended to take the rifle apart after the shooting. I think that was pretty brilliant. The state did not present any evidence as to how the screwdriver could have been used to disassemble and reassemble this weapon in the period of time at issue, right? 40 seconds. Even if the court draws inference, there's a connection between the rifle and the screwdriver. The court cannot then reasonably infer from this inference a rifle deconstructed and then reconstructed would be less accurate, let alone that the shooter knew of that risk. Okay. Hang in there. We're almost done, y'all. They say that the shooter may have known there were people behind the pop-up tent when the single shot was fired, although the state's evidence shows otherwise. Yeah, so they say it's reasonable to infer that he could see people in the area behind the tent. Earlier that morning, he had been down to the amphitheater area to interact with some TPUSA representatives and would have firsthand seen the staging area. And he was thus aware of the existing circumstances, meaning that people were near Charlie. Defense goes on to say the state's assertion that he would have known there were people behind the pop-up tent is not a reasonable inference supported. Their own evidence shows that no one was directly behind where Charlie was. And then they quote it, no one stood behind the middle of the tent. Moreover, shooter could not, of course, see through the tent, right? She asked that question too. I was like, where's she going with this? It was white. It was not opaque. And was on the rooftop bandage for only 35 to 44 seconds before taking a single shot with a precision scope. So I think the scope could show that he knew it was, that lends to accuracy, like it would be another thing if you didn't have a scope on it. Okay. So more on this one. The defense says that the state relies on surveillance footage from earlier in the day to suggest that he would have known that people were behind the pop-up tent, which there weren't. But he was on campus at 8:30 and went there 3.5 hours. The state asked this court to speculate that the amphitheater, people around it looked to the shooter at this time, just as it did 4 hours later when the shot was fired. There's no evidence from which this court can make such an inference. And again, the evidence is that shooter had an extremely narrow window of time to observe the intended target, which would be Charlie, and the only reasonable inference can be drawn is that he saw Charlie. Like, that's a totally reasonable inference. Oh, what has happened here? Okay. Let's see. They go on to babble about things that are really irrelevant. They don't. Let's see. This is the last page here. Let me see what I did. Looks like I cut it off. Okay. So let me just read it to you, and then we'll be done, since it splits off for y'all. Sorry about that. So they're done with that argument, and they say, many of defendants' arguments depend on ignoring some evidence and improperly viewing evidence in his favor. They say that his argument that the evidence does not establish probable cause is unpersuasive because he ignores evidence and improperly views other evidence and reasonable inferences in a light most favorable to him. I still haven't seen, this is the very end of that portion of the brief, and they have not said how, they have not argued how the defense, how their argument saying that this stuff is not reasonable. They did not take the opportunity to say why it's reasonable. Let's see. And they just go on to talk more about the fact that he loaded it with 4 rounds, and it's in his bad target practice. Let's see. Whether the targets are related to the murder or not, their presence in his apartment supports a reasonable inference that they record his shots. The targets show that he seldom hit the bullseye and sometimes missed the target altogether. And then they say, we've met the probable cause for aggravated murder, and that is it. So very good, you guys. You made it through. What do y'all think? Yeah. Real Housewife of Salt Lake City. So, okay, from the position of an attorney, right, like, you get cases sometimes that are not great and you have to do your best. And to me, this is their best, but I really think when it's somebody's life on the line and you're pushing for the death penalty, it's an abuse of government power. Yeah. I heard that the prosecution was not happy to take this case. So, I mean, from an attorney's standpoint, they're doing the best that they have, but even more reason to drop it. Let's see. Let's take here. Y'all don't have to stare at that. Y'all can look at me. There you go. I think that's all. Let me see if I had anything else. Let me see if I had anything else for y'all. Not that you need it. No, let's remove this one. Oh yeah. We won't go through this. If y'all have been in the other lives, you will know how the line of sight in anyone near those two arguments failed as a matter of law. I'm just looking at this. Y'all don't need that though. We're good. I think we covered it sufficiently. Yeah. I think the fact that they didn't just charge him with murder, because Charlie's the only one who died. Nobody else was hurt or injured. There's no, and the way I'm thinking is like, I know it's the state that brings the suit on behalf of the people and the victims, right? But like, nobody else is included as a victim here. They are not even naming the questioner, Hunter Kozak, by name. So they're just kind of using the fact that he was close to Charlie as a way to try to get aggravated murder. But like, what if Hunter Kozak was like, or all these people said, hey, no, like, don't prosecute on behalf of me. I don't want you pressing charges on my behalf. But did they ever ask them that? No. I think it's a solid a solid point that needs to be discussed further. Like, if there is no other victim, on whose behalf are you bringing this? Like, Charlie's the victim. Yeah. They're doing their best with the slot. Yeah. Yeah. Lower murder case. Yeah, of course. Yeah, absolutely, Bonnie. Because, and going back to it, it's like the murder case is just defendant knowingly killed somebody. Why they didn't just bring that, I don't know. It's because they want him to go away. But I mean, this is somebody's life, It's not a joke, and it's pathetic that this is their. It's pathetic that he's potentially on trial for this, and this is the best they can do at this stage. It's at this stage that they should have brought, A game. Hi, baby. I know, he wants to go on a walk so bad. You'll get your turn. All right, y'all. What do y'all think? Any last final thoughts? Thank you for sitting here with me. I know it's like rough, but hopefully it was in a smooth manner that was easy to digest. But now that is what we're looking at. Everything we've done. This is what we're heading into the decision that the court is going to render, whether or not we're going to trial on that. We will go to trial on some of the other things, but it doesn't mean that you go to trial on all counts. But this is definitely the most important one. I don't know. Who survives this, it'll be a good book deal. There's something, though. Part of me has wondered if they intentionally did like what I think is an unconstitutional search and seizure of the car. And a lot of the other stuff that they haven't brought up, the prosecution, it's not on the defense right now. And with these kind of arguments, I almost wonder if part of the plan is now to get him off the hook without it looking like they're getting him off the hook, because he didn't do it. Like, are they intentionally throwing this? I feel bad for the prosecutors, because the prosecutors don't have a choice. Like, this was they had a choice in what they charged him with. They could have just charged him with murder. But then again, if we're thinking about nefarious activities by our government, it could be that the murder charge was going to get him, at least to a trial. Maybe they don't want him to go to trial. It could be that they don't want him to go to trial, so maybe they were like, look, we reach high and bar, and we make these egregious, pathetic arguments. Because they could have had probable cause for murder easy. That's easy. That would have been going to trial. So this makes me think that they charged him with aggravated murder to make sure it didn't go to trial. Yeah. Well, the other charges don't necessarily fall apart without the first, because it's probable cause for each one of them. And let's see what we're specifically. Let me find them. Let me look. Guys. Okay. So, charge 1 is aggravated murder that we've been doing. Charge 2 is discharge of a firearm causing serious bodily injury. So that would be in, right? But that's probably going to be a bind over for trial. Because if we take the prosecution's argument on its face, like he did discharge a firearm causing serious bodily injury, right? So that one, I bet we go to trial on. Obstruction of justice for removing the firearm. And then there's another count for removing his clothing. And then tampering with a witness, telling him not to delete the text. And then another one saying don't speak with that lawyer. Probably won't go on both of those. And then there's a 7th one that we haven't talked about, but it's violent offense committed in the presence of a child. So, I mean, that is that's an enhancement of a sentence, meaning it's a class A misdemeanor. But those are, I think that our first review of this, we did the 2 obstruction of justice and the 2 tampering of witnesses. So I don't know what they're going to do. Let's see. Oh, yeah. KZ, I agree. KZ says, I'm no lawyer, but we've all watched enough public trials last few years to know that this is kind of BS. Well, Karen Reed, thank goodness that turned out the way it did. But that poor woman, can you imagine the stress? I mean, maybe they'll be like, hey, as long as you don't sue us for malicious prosecution, we will let go. Yeah. They can't have Tyler speaking, so I don't know. Well, look, you can't double jeopardy is a thing. So if they dismiss these charges against him, even if he comes out later and says, yeah, I did it, or this is what happened, just like O.J. Simpson did, you can't be retried. I mean, the kind of stress that they put on Karen Reed is insane. Was insane. I love the way she was dressed. I was like, oh, I want her whole wardrobe. Just recycle it. Let me have it. Okay, y'all. Thanks for hanging in there. I'm going to let y'all go. The court is dismissed. You guys are troopers. Thank you for showing up, because it took everything out of me today to put this together. And I am still a full-time working lawyer, so it's a lot. But I love doing this and covering this and connecting with you guys. So yes, you're welcome. You're welcome. Do the state have to identify the child, for example, actual 1-year-old that was there? Or Yeah, I'm sure they do. I'm sure that they would have to. But what's interesting is that well, I think that they did. I think the probable cause, the initial memo, I think it did have the actual, a couple of children listed in it. But I don't know. That's a really good point. If they didn't, oh, was Nate on? You're welcome, Bonnie. Yes, Casey has a great idea. If you want to support me, we're obviously not monetized yet. We're really close. You can go find the link in the show notes or on X. And if you want to, you can buy me a coffee. That would be so appreciated if you do. If not, that is all good too. And thanks for being here because it really helps the channel grow. Oh, it's okay, Trash. Don't even worry about it. You just being here is good. It's good. And thank you for everybody who engages in the dialogue too. It's nice to see what you guys think, and it's good to see you guys bonding over that. So I love you guys. Tomorrow, I don't know if Barron has announced whether or not he's going. I know like last night he said maybe like a 75 to 85% chance he's going tomorrow. He might have said differently today. But I'm going to try to do that like 4:35 time slot. I do apologize for having to bump it up sometimes, but well, like every time I've had to bump it up. But as you can see, there's a lot that goes into this. So, but tomorrow we'll try to do a 4:30 or 5. If Barron's not going, if he goes, then I will go after him because I know we all watch him too. So, love you guys. If you want to support me, click the link to buy me a coffee. Otherwise, I will see y'all tomorrow. Love you.